After studying this module, you shall be able to understand the concept of secondary market, learn about stock exchange in India with its functions, know various intermediaries in secondary market, identify process of trading in secondary market, learn the concept of margin money, and know the development of secondary market. We shall commence our discussion by studying about SEBI. The SEBI of India was established in April 1988. It has been functioning in full administrative control of the Government of India. It works under the agent of central government in capital market. It is established for regulation and orderly functioning of the stock exchanges. It also works for protecting the investors' rights, prevents malpractices in security trading, and promotes healthy growth of the capital markets. It was granted statutory status in the year 1992 under SEBI Act. It has the full authority to control, regulate, monitor and direct the capital markets. It is the watchdog of the securities market. It is the most powerful organ of the central government in the capital market. After the repeal of Capital Issue Control Act, abolition of CCI, the SEBI was given full powers on the new issue market and stock market. It has been issuing guidelines since the year 1992 in the month of April for all financial intermediaries in the capital market. The guidelines have been issued with the objective of investor protection. The guidelines also include the obligations of merchant bankers in respect of free pricing, disclosure of all correct and true information, and to incorporate the highlights and risk factors in investment in each issue through the prospectus. It has been established for the healthy development and regulation of the capital market. We shall now throw some light on various objectives of the SEBI. The main objectives of SEBI are to save the rights and interests of investors, particularly individual investors, and to guide and educate them. Next, to prevent trading malpractices like rigging the price, insider trading, misleading statements in prospectus, etc. Then, to regulate stock exchanges and the securities market to promote their orderly functioning. The next is to registering and regulating the working of stockbrokers, sub-brokers, etc. Then, to promote the development of securities market, and lastly, in promoting and regulating self-regulatory organizations. Now let us know and understand what the constitution of SEBI is. The central government has been constituted by a board by the name of SEBI under the section 3 of SEBI Act. The head office of SEBI is in Mumbai. SEBI may establish offices at other places in India as well. SEBI constitutes of the given members such as A. The chairman, B. 2 members which are selected from the officials of the Ministry of Central Government. These people are dealing with finance and administration of Companies Act 1956. C. 1 member is drawn from the officials of Reserve Bank of India. Lastly, and D. 5 other members, of which at least 3 will be full-time members. These are appointed by central government. The management, general superintendence and direction of the affairs of SEBI lie in a board of members. It exercises all powers and does all acts and things which may be exercised or done by SEBI. The chairman also has powers of general superintendence and direction of the affairs of board, and may also exercise all powers and do all such acts and things which may be exercised or done by the board. The SEBI is a very powerful and important organ in capital market. It represents the central government. It is a statutory body in the capital market. It leads, monitors, regulates and controls the activities of capital market. The organization has divided its activities into 5 operational departments. Each department will be headed by an executive director. The legal department and investigation department also are headed by the executive directors. The following are main departments which are functioning in the organization. 1. Primary Market Department. The Primary Market Department is the most important division in the organization of the SEBI. It deals with new issue market activities. It is headed by a division chief with specific responsibilities. It relates to the policy matters of public issues. It looks after all regulatory issues for the primary market in India. It also involves in regulatory matters with regard to the financial intermediaries. It also looks after the investors' grievances. It deals with investor complaints for refund of application money, for non-allotment refund of excess money, non-receipt of dividends, non-receipt of share certificates, etc. Therefore, it has the full authority with reference to public issues and public matters. 2. Issue Management and Intermediaries Department. This particular department will take care of critical examination of offer documents. The offer document is the most important paper in public issue. It is the tool for attracting investors. It is the basic document which is promised by the company to newly becoming shareholders. The offer document should contain only facts and a right of projection about future. Some companies can misguide the investors by creating a gloomy picture about their product and company. Therefore, this department shall closely monitor the contents of the offer documents. This department also involves in the registration of financial intermediaries. It also monitors the activities of various financial intermediaries. 3. Secondary Market Department. It occupies a vital role in the regulation of capital market operations. It takes into account of framing the policy matters regarding stock exchange activities. It controls the secondary market activities also. It also guides and monitors the stock exchange administration. It continuously monitors the price movement in the stock market. It involves in the development of new investment products. It closely observes the market movements and gathers information through market surveillance. It also looks about the insider trading practices. It makes the policy and also develops the regulatory matters. It is basically done for secondary markets in India. Also, it gives directions to the administration of stock exchange authorities on various matters. It also takes into account the affairs of stock exchange administration, inspection by making inquiry towards financial intermediaries. It also regulates the sub-broker activities. 4. The Institutional Investment Department. This department makes various policy matters in regard to the institutional investors. These are more important in the capital market. They will keep the higher amount of investment in the stock markets. They are involved in the buying and selling of shares with crores of investment. The following members will be treated as institutional investors. namely A. Mutual funds, B. FII, which means foreign institutional investors, C. Corporate investors, lastly D. The institutional investors. It takes care of mergers and acquisitions in the corporate sector. It also concentrates on research and publications. It also maintains international relations in the process of globalization. It makes the policy matters for investors who are institutional investors. The education of the investor has also emerged as an important part of SEBI's efforts to protect the interest of investors in securities market. 5. Legal Department. The Legal Department undertakes the job of providing legal advisory services to the organization. It also handles all litigations and other legal issues. 6. Depository Department. This department regulates and promotes the market for derivative instruments. Lastly, 7. Takeover Department. This department takes care of substantial acquisitions of shares and takeovers of companies. Five. Functions of SEBI. Let us now understand the functions performed by SEBI. SEBI has the responsibility to safeguard the interests of investors in securities and to enhance the development of and regulation of securities market by such measures as it thinks fit. The measures referred to therein may provide for protective functions, that is, it stops and bans unfair trade practices in the securities market, for example, price rigging, market misleading statements in prospectus manipulations, etc. It controls insider trading and imposes penalties for such practices. It undertakes steps for investors' protection and it promotes fair practices and code of conduct in securities market. Now let us know the regulatory functions of SEBI. The regulatory functions include, it involves regulation of the business in securities market and other stock exchanges. It involves registration and regulation of the working of a variety of agents such as stockbrokers, share transfer agents, bankers and sub-brokers to a given issue, trustees belonging to trust deeds, registrars for a particular issue, underwriters, merchant bankers, portfolio managers, investment advisors and many other intermediaries who may be associated with securities market in any manner. Registration and regulation of participants working, depositories, custodians of securities, FNIs, credit rating agencies and many other intermediaries, for example, SEBI may by notification specify in this behalf. Registration and regulation in the working of venture funds and collective investment schemes, which include mutual funds, regulating substantial acquisition of shares and takeover of companies. And lastly, promoting and regulating self-regulatory organizations. Let us now know the development functions of SEBI. These functions include promotion of the education of investors and their training of intermediaries of securities markets, banning any company to issue prospectus, any other document or advertisement soliciting money from the public for issue of securities, and for conducting research and publication of information that is useful to all market participants. We shall now discuss the powers of SEBI. The powers of SEBI have been given by the enactment of SEBI Act 1992. These powers include, number 1, regulating the business activities in the capital market, 2, Power to grant registration to financial intermediaries. 3. Register and regulate how the depositories work. Working of the custodians, FIIs, credit rating agencies is also seen. Registering and regulating the working of venture capital funds and mutual funds is the fourth power. Fifth, power to grant approval to bylaws of recognized exchanges. 6. Power to prohibit insider trading. 7. Power to compel listing of securities by public companies. 8. Power to control and regulate stock exchanges. 9. Power to call for any information or explanation from recognized stock exchanges or its members. 10. Power to levy fee. 11. Power to regulate substantial acquisition of shares and takeover of companies. 12. Power to promote and regulate self-regulatory bodies. 13. Stopping fraud and unfair trade practices which relate to securities market is the next power. 14. Power to promote investors' education and training. 15. And lastly, performing any other function as may be assigned by the government from time to time. Let us know the IPO's regulatory background. In one of the board meetings of SEBI held on November 9, 2009, a decision was made by SEBI. It stated that an SME exchange should be established and developed. SEBI released a circular on May 18, 2010. It prescribed the framework for setting up of SME exchange or an SAP platform for BSE or NSE. In the year September 2011, SEBI made amendments in the ICDR regulations to enable IPOs for listing on SME exchange or platform. Dedicated platform have been created at BSE and NSE for SME. The BSE launched its platform on March 13, 2012. NSE has branded its SME platform as Emerge and launched it on March 13, 2012. Let us understand important regulations for SME IPOs. Number 1. Underwriting of IPO is compulsory. 2. Merchant banker must underwrite at least 15% of IPO. 3. Minimum number of allottees is 50. 4. Minimum application size is Rs 1 lakh. 5. Market making is compulsory for 3 years. And lastly, filing DRHP or prospectus with SEBI is not required. Let us now understand the meaning of institutional trading platform. In the budget speech, the finance minister made an announcement that startup business and SMEs can get themselves listed on the bourses without an IPO. Stock Exchange Bureau has also made the provision in ICDR guidelines. It has introduced Chapter 10C in which listing on the stock exchange is made possible without bringing IPO. SEBI has given notice on the same date, that is 8th October 2013, and also issued a detailed circular on 24th October 2013. The benefits of listing on ITP are as follows. It raises capital by small and medium enterprises with startup companies which are in their early stages of growth. It provides an easy entry and exit options for informed investors like angel investors, VCFs and PEs, etc. to and from such companies. It provides a better visibility and wider investor base. It results in a relaxed compliance and cost-effective listing. It results in tax benefits to long-term investors. Let us now know the eligibility criteria for listing. Number 1. Regulatory criteria. The company and its promoter and the group company and the director of the company will not appear in the list of defaulters of RBI as maintained by CIBIL. No option is given for closing up of the petition against the company which was admitted by a competent court. The company and all its group companies and the subsidiaries are referred to as Board for the Industrial and Financial Reconstruction. It is done in a time period of 5 years before the date of application for listing. The regulatory actions are not taken against the company, the promoter of the company or director, by the Board, Reserve Bank of India, Insurance Regulatory and Development Authority or Ministry of Corporate Affairs within a period of 5 years prior to the date of application for listing. Let us now discuss the exchange criteria. The company will satisfy at least one of the criteria as on the date of application. Net tangible assets of minimum of rupees 1 crore, that is net capital assets plus net current assets, or net income, that is excluding extraordinary and other incomes, of rupees 50 lakhs as per latest audited financials, that is net income is equal to sales minus purchases. There has been no change in the promoters of company in preceding 1 year from the date of filing of applications to BSE for listing on ITP segment. Mandatorily signing tripartite agreement with both the depositories. We shall now study about investor protection. Keeping in view the importance of investor protection for the growth of securities market, SEBI has introduced several provisions in the form of various rules and regulations in the primary market and secondary market to ensure fair and smooth trade in securities. Under Section 11A of SEBI Act 1992, SEBI for protection of investors may specify the manner in which the matter relating to issue of capital, transfer of securities and other matters shall be disclosed by companies. Prohibit any company from issuing prospectus, any offer document or advertisement for issue of securities. Specify the requirement for listing and transfer of securities. No company can make an issue of securities unless a draft prospectus has been filed with SEBI. No company shall make an issue of securities unless it has made an application for listing of securities at a stock exchange. No company shall make a public issue of shares unless all existing shares are fully paid. An unlisted company can make issue of shares if A. It has not tangible assets of at least 3 crores in each of the 3 preceding years. B. It has a track of distributable profits for 3 years out of 5 preceding years. And lastly C. It has net worth of at least 1 crores in 3 out of 5 preceding years. The lead merchant banker is required to exercise due diligence as a pre-issue obligation. No company is to make issue of debt instruments unless a credit rating of not less than investment grade has been obtained for the debt instrument. In public issue by an unlisted company, the promoter shall contribute at least 20% of the post-issue capital. An issue advertisement shall be truthful, fair and clear and not contain any statement which is untrue or misleading. We shall now discuss about investor education. SEBI constituted a working group on investors' education to advise SEBI on matters relating to investors' education. The objectives of this is to make an investor aware of number 1, the right he has as a shareholder, number 2, the responsibility he has as an investor, number 3, the risk which is assumed by an investor, 4, the procedure relating to trading and transfer of securities, and lastly 5, the remedies for problems that he may encounter. Let us now know the rights of an investor. The investor has a right to receive the share certificate on allotment or transfer, as the case may be, in due time, to receive copies of director's report, balance sheet and profit and loss account and the auditor's report. Right to participation and voting in general meeting. It can be done either personally or through proxies. He has a right to receive dividend in the given time once it is approved in general meeting. The investor has a right to receive corporate benefits like rights, bonuses, etc. The investor also has a right to apply to Company Law Board or call or direct the annual general meeting. He has a right to proceed against the company by way of civil or criminal proceedings. And lastly, the investor has a right to receive the residual proceeds. Let us now understand how investors' grievances are redressed. In order to provide better and transparent system of redressal of grievances of investors, the SEBI, that is an Ombudsman Regulation 2003, have been issued. The Ombudsman shall have the following power and functions. A. To receive complaints specified in Regulation 13 against any intermediary or listed company or both. B. To consider such complaint and facilities resolution thereof by amicable settlement. C. To approve a friendly or amicable settlement of the dispute between parties. D. To adjudicate such complaints in the event of failure of settlement thereof by friendly or amicable settlement. A person may lodge a complaint on any one or more of the following grounds, either in the board or to the ombudsman or ombudsperson concerned. For number 1, non-receipt of refund orders, allotment letter in respect of public issue of securities of companies or units of mutual funds or collective investment schemes. 2. Non-receipt of share certificates, unit certificates, debenture certificates, bonus shares, etc. Non-receipt of dividend by shareholders or unit holders. Non-receipt of interest on debentures, redemption amount of debentures or interest on delayed payment of interest on debentures. Non-receipt of interest on delayed refund or application monies. Non-receipt of annual reports or statement pertaining to the portfolios. Non-receipt of redemption amount for a mutual fund or returns from collective investment schemes. Non-transfer of securities by an issuer company, mutual fund collective investment management company or depository within the stipulated time. Non-receipt of letter of offer or consideration in takeover or buyback offer or delisting. Non-receipt of statement of holding corporate benefits or any grievances in respect of corporate benefits. Any grievance in respect of public right or bonus issue on a listed company. Any matter covered under section 55A of the Companies Act 1956. And lastly, any grievance in respect of issue or dealing in securities against an intermediary or a listed company. We will now study the concept of insider trading. Insider trading is the trading of a public company's stock or other securities such as bonds or stock options by individuals with access to non-public information about the company. In various countries, insider trading based on inside information is illegal. This is because it is seen as unfair to other investors who do not have such access to the information. The insider trading is a broader sense, includes any attempt to, number 1, benefit the individual or other agency indulging in such practice, 2, benefit the company through such action by using price sensitive information. Insider trading may benefit some person at the cost of others. As a part of investor protection, SEBI has taken necessary steps to prohibit insider trading by checking and curbing unhealthy and manipulative practices by persons who have more access than others of the information about the company. Price sensitive information means and includes any information which relates directly or indirectly to a company which, if published, is likely to materially affect the price of securities of the company. Price sensitive informations include 1. Periodic financial results of the company, 2. Intention to declare dividend, 3. Issue or buyback of securities, 4. Expansion plans, projects, mergers, amalgamations by the company, disposal, 5. Disposal of whole or part of the undertaking, and 6. And lastly, significant changes in policies, plans of the company. Let us now recapitulate what we have learned so far in this module. The Securities and Exchange Board of India, frequently abbreviated SEBI, is the regulator for the securities market in India. It was established in the year 1988 and given statutory powers on 12th April 1992 through the SEBI Act 1992. In the budget speech, the Honorable Finance Minister announced that the startups and SMEs can get listed on the browsers without IPO. The basic functions of the Securities and Exchange Board of India is to protect the interests of investors in securities and to promote the development of and to regulate the securities market and for matters concerned there with or incidental thereto. SEBI has 3 functions rolled into one body: quasi-legislative, quasi-judicial and quasi-executive. It drafts regulations in its legislative capacity. It conducts investigations and enforcement action in its executive function, and it passes ruling and orders in its judicial capacity. Though this makes it very powerful, there is an appeal process to create accountability. Insider trading is the trading of public companies' stock or other securities such as bonds or stock options by individuals with access to non-public information about the company. In order to provide better and transparent system of redressal of grievances of investors, the SEBI has an ombudsperson, Regulation 2003, which have been issued to protect interests of the investor.